Here's what they're not showing you: a forgotten microphone, a conversation that was never meant to be heard, and a judge who stopped an entire trial the moment he realized what was happening. Judge Caldwell didn't raise his voice. He didn't slam a gavel. He did something far more terrifying. He went completely silent. Then he ordered the U.S. Marshals to seize the defense laptop right there in front of the jury, in front of the cameras, in front of the defense attorneys who suddenly looked like they'd seen their entire careers flash before their eyes. What was on that laptop? What was in that recording? And why is everyone involved suddenly refusing to talk? I've watched the footage 17 times, and every viewing reveals something new. So what pushed Judge Caldwell over the edge? One moment, one decision, one line. The defense team should never have crossed. A microphone left active during a recess picked up a conversation between the lead defense attorney and someone who shouldn't have been talking to them at all. But here's the thing: this wasn't random. This was weeks of suspicious behavior finally catching up, and I'm going to show you exactly how it all fell apart. The case itself was already explosive. A high-profile fraud trial, millions of dollars, powerful people with everything to lose, the kind of case that makes careers or destroys them. Judge Caldwell had been presiding over this trial for 3 months. 3 months of motions, objections, and a defense team that seemed just a little too confident, just a little too prepared for every prosecution move. Everyone noticed. Nobody could prove anything. Until that microphone stayed on, until that conversation was captured, until Judge Caldwell heard something that made him stop everything. The moment everyone's talking about it's coming. But first, you need to understand what the defense thought they were getting away with. Because when you see the full picture, you'll understand why Judge Caldwell did what he did. Here's what actually happened the moment everyone clicked to see. Tuesday morning, 10:47 a.m., courtroom 4B of the federal courthouse, the kind of room where careers end and legacies are written. Judge Caldwell had called a 15-minute recess, standard procedure. The jury filed out, the prosecution gathered their notes, and the defense team huddled in the corner of the courtroom, voices low, assuming what everyone assumes during a break, that no one was listening. They were wrong. The courtroom's audio system, installed for ADA compliance and record-keeping, has microphones throughout the room. During active proceedings, only specific zones are live. During recess, the system is supposed to go dormant. Supposed to. A technical glitch or maybe something else kept the defense table microphone active, and it captured everything. The lead defense attorney speaking in hushed tones, he confirmed the witness changed her story. "We have the new version. They don't know she talked to us." Then another voice, unidentified at first, but clearly not part of a legal team. "She's scared. She'll say what we told her to say. Just make sure the judge doesn't find out about the contact." The conversation continued for 2 more minutes. References to adjusted testimony, mentions of the arrangement, and a chilling phrase that made Judge Caldwell's blood run cold. Caldwell won't know until it's too late. The audio was being monitored in the clerk's office, standard security protocol. Within 60 seconds, the recording was in Judge Caldwell's chambers. He listened once, then he walked back into that courtroom. Witnesses say his face was completely neutral. No anger, no shock, just absolute terrifying calm. He didn't address the jury. He didn't address the prosecution. He looked directly at the defense table. "Mr. Harrison," he said, his voice flat, "please remain seated." The lead defense attorney started to stand anyway, started to object. "I said remain seated." That's when the marshals moved, not toward the attorney, toward the laptop sitting open on the defense table. "Your Honor, this is outrageous," Harrison began. "What's outrageous?" Judge Caldwell cut in, is what I just heard on the courtroom audio feed. "The laptop is being seized as evidence. Your entire team is ordered to surrender all electronic devices now." The courtroom erupted. The jury was rushed out. The prosecution sat frozen, clearly having no idea what was happening. And the defense team, 3 attorneys, 2 paralegals, watched as everything they brought into that courtroom was bagged and tagged. But here's what nobody saw coming. Judge Caldwell wasn't done. "This trial is suspended pending investigation. Mr. Harrison, you are hereby ordered to remain in this jurisdiction. All defense counsel are barred from contacting the defendant, the witnesses, or each other until further notice." Harrison's face went white, actually white, the kind of pale that comes from realizing your entire career just imploded in 90 seconds. "Your Honor, our client has rights." "Your client's rights are not the issue, counselor. Your conduct is." And then Judge Caldwell said something that made every attorney in that courthouse sit up straight. "Federal marshals will escort you to processing. You are not under arrest yet, but obstruction of justice, witness tampering, and conspiracy charges are being evaluated as we speak." The courtroom fell silent, completely silent, because everyone understood what had just happened. A sitting federal judge had just caught defense attorneys allegedly coordinating testimony with a witness on tape in his courtroom, and he had responded with the judicial equivalent of a nuclear strike. If you're watching this thinking finally someone's covering the full story, hit subscribe. I'm going deep on this case because what I'm about to reveal next about those defense attorneys, nobody else is connecting these dots, but not everyone sees it that way. Defense advocacy groups are calling this a dangerous overreach, and honestly, when you hear their argument, you might understand why some people are worried. The National Association of Criminal Defense Lawyers released a statement within hours. The seizure of privileged attorney-client materials without proper warrant procedures sets a terrifying precedent. Judge Caldwell may have acted on emotion rather than law. One prominent civil liberties attorney put it this way: think about what happened here. A judge heard something he didn't like during a private conversation and immediately seized property. What about the Fourth Amendment? What about attorney-client privilege? These protections exist for a reason. Social media is exploding with divided reactions. Posts saying the judge was a hero, posts calling him a tyrant. Legal Twitter has been an all-out war for 48 hours straight. And here's the uncomfortable truth: there are real questions about how this was handled. Was the audio recording legal? The defense table wasn't supposed to be monitored during recess. Is that evidence even admissible? Did Judge Caldwell have the authority to seize the laptop without a warrant? Legal experts are genuinely split. And what about the unidentified voice on that recording? If it wasn't actually witness tampering, if it was something else entirely, did Judge Caldwell just destroy an innocent defense team's ability to represent their client? Judges don't get to become prosecutors. One critic said on cable news, he heard something, assumed the worst, and acted as judge, jury, and executioner of this defense team's careers. That's not justice. That's vigilantism in a robe. So, who's right? Is Judge Caldwell actually a hero who caught corruption in real time? Or did he just show what happens when judges let their emotions override proper procedure? That's the question nobody wants to answer. And the more you dig into this, the messier it gets. But this didn't come out of nowhere. Weeks before this explosion, the warning signs were everywhere. It started with a witness, Maria Delgado, a former accountant for the defendant who was scheduled to testify about falsified financial records. Her original deposition was devastating for the defense. Clear, detailed, damning. Then something changed. 3 weeks before trial, Delgado's attorney contacted the prosecution with a revised statement. Suddenly, the numbers she'd been so certain about were unclear. The documents she'd authenticated were possibly misremembered. Her rock-solid testimony had turned to sand. The prosecution flagged it immediately. They told Judge Caldwell something felt wrong. Did the defense cross a line? They couldn't prove it. I expressed my concerns directly. The lead prosecutor said in a filing, the court acknowledged but stated there was insufficient evidence to act. Judge Caldwell's hands were tied. Suspicion isn't proof, and the defense was entitled to the presumption that their tactics were legitimate. But everyone noticed the defense's cross-examinations were too perfect. Their objections anticipated prosecution moves before they happened. Their witness preparation was almost supernatural. Every week they seemed to know exactly what was coming. Judge Caldwell reportedly told his clerk, "Something's not right. I can feel it, but I can't act on feelings." Until he didn't have to rely on feelings anymore. That forgotten microphone gave him something he'd been waiting weeks for. Evidence, real evidence, recorded evidence, evidence that didn't require interpretation or speculation. The stage was set. The defense had been pushing their luck for months, and they had no idea that one technical glitch, one microphone that stayed active, would be the trap that ended everything. Judge Caldwell had been watching, waiting, knowing something was wrong, and when the proof finally landed in his lap, he didn't hesitate. Not for 1 second. Drop a like if you see where this is going, because the courtroom seizure was just the beginning. What happened in the 48 hours after? That's where this story goes from dramatic to absolutely insane. And then it happened. The marshals approached the defense table, 3 of them moving with the kind of purpose that told everyone in that room this wasn't a request. Harrison stood anyway, his hand reaching for the laptop. Don't. One word from Judge Caldwell, one word that froze Harrison mid-motion. The lead marshal, a 20-year veteran named Patterson, stepped between Harrison and the table, gloved hands, evidence bags ready. "This is privileged material," Harrison started. "Not anymore." Judge Caldwell's voice carried across the silent courtroom. "Privilege does not extend to evidence of ongoing criminal activity. You know that, or you should." The laptop was bagged, then the phones, then the tablets, then the external drives. The defense team stood there. 5 legal professionals watching their entire case, their files, their communications, their careers being carried out of the courtroom in clear plastic bags. 45 seconds, that's all it took. 45 seconds and everything changed. But here's what everyone missed. While they were focused on the seizure itself, Judge Caldwell had already made a phone call. During that 15-minute recess, after hearing the recording, he'd contacted the U.S. Attorney's Office directly. By the time those laptops were being bagged, Federal investigators were already on their way. This wasn't an emotional reaction. Judge Caldwell had watched this defense team for weeks. He'd suspected something was wrong, and the moment he had proof, he'd executed a plan. The seizure was public, dramatic, impossible to hide or spin, but the investigation had already begun before the defense team even knew they'd been caught. Judge Caldwell had coordinated with federal prosecutors. He'd ensured the audio recording was preserved with proper chain of custody. He prepared the legal justification for emergency seizure under the crime fraud exception to attorney-client privilege. This wasn't judicial overreach. This was a chess master springing a trap he'd been building for months, and the defense team walked right into it. Don't go anywhere. What I'm about to reveal changes everything about how we understand this case. Drop a comment right now. Do you think Judge Caldwell was right to seize those devices? I want to see where you stand. People who do this for a living are calling this unprecedented. A former federal prosecutor, someone who's been in courtrooms like this for over 2 decades, explained it this way. In my entire career, I've never seen a sitting judge take action this decisive, this fast, on evidence of witness tampering. Usually, these investigations take months. Judges are cautious to a fault. Caldwell moved like a prosecutor, and legally, he may have been completely justified. What does that mean in plain English? Judge Caldwell didn't just react, he anticipated. He'd been building a mental case file for weeks, and the moment evidence appeared, he knew exactly how to use it. And here's what legal analysts are whispering to each other behind closed doors. The crime fraud exception is real. If communications between attorney and client are used to further ongoing criminal activity, privilege evaporates. Caldwell clearly believes he caught them in the act. If he's right, everything on those devices is fair game. But it's not just prosecution-minded voices. Even defense attorneys are admitting there's something to this. Look, I defend the accused for a living, but if what's on that recording is what they're saying, those attorneys weren't defending anyone. They were participating in obstruction. That's not zealous advocacy, that's criminal conspiracy. The real question experts are wrestling with: did Judge Caldwell have enough to justify the seizure in that moment? The recording captured suspicious conversation, but was it enough? Did he hear actual evidence of a crime, or just concerning language that could be explained away? This will be litigated for years, one analyst predicted. Every piece of evidence that comes from those devices will be challenged. Defense attorneys nationwide are watching this case to see if Caldwell's seizure survives appeal. The message is clear. Judge Caldwell bet his entire career on this moment. If he's right, he's a hero. If he's wrong, he's destroyed his legacy and possibly let a guilty defendant walk free. Smash that like button if this analysis is opening your eyes to how complex this situation really is, because the implications of what happened in that courtroom, they go way beyond this one case. So, what does this mean for you? Right now, every defense attorney in the country is reviewing their courtroom procedures. If a forgotten microphone can capture private conversations, what else is being recorded? Federal carousers across America are reportedly auditing their audio systems. Here's the thing. This affects every person who might ever need a defense attorney. Are your private conversations with your lawyer actually private? After this case, nobody's sure anymore. In the next few months, expect a flood of motions and cases nationwide. Defense teams are going to challenge courtroom recording procedures everywhere. Cases might be delayed. Verdicts might be appealed. The ripple effects are already spreading. If you're someone who follows the legal system, or if you've ever worried about the balance between justice and privacy, this case is about to become the most important precedent of the decade. But the bigger picture, that's what keeps me up at night. If Judge Caldwell's seizure is upheld, it creates a roadmap for judges everywhere. Suspect your attorneys are playing dirty. Wait for them to slip up on a hot mic and seize everything. On one hand, accountability. Corrupt lawyers should be caught. On the other hand, what happens when a judge is wrong? What happens when an innocent conversation is misinterpreted and a defendant loses their entire legal team based on a misunderstanding? And here's what nobody wants to talk about. What if the defense team was actually innocent? What if that conversation was taken out of context? What if adjusted testimony meant legitimate witness preparation? What if the arrangement referred to a legal fee structure? What if Judge Caldwell, convinced of wrongdoing after weeks of suspicion, heard what he wanted to hear? Right now, careers are destroyed. A trial is suspended. A defendant is in legal limbo. And if it turns out the recording doesn't prove what everyone thinks it proves, there's no undo button for this. The defense attorneys can't unexperience being walked out of a courtroom by marshals. The defendant can't unlive months of additional incarceration while this gets sorted out. And Judge Caldwell can't unmake a decision that was broadcast to the world. That's not a comfortable thought, but it's the reality of what happens when justice moves at the speed of instinct rather than investigation. And then the defense team made it worse. Instead of staying quiet, instead of letting their attorneys handle it, lead counsel Harrison held an impromptu press conference on the courthouse steps. Big mistake. Judge Caldwell has engaged in judicial tyranny, Harrison declared, face flushed, voice shaking with barely controlled rage. He has violated our constitutional rights based on a recording that was illegally obtained. We will fight this to the Supreme Court if necessary. The reaction was immediate and brutal. Legal analysts pointed out that attacking the judge publicly while under investigation for witness tampering was perhaps the worst possible strategy. One commentator called it pouring gasoline on a fire while standing in the flames. But here's where it gets dangerous. Within 24 hours, the defendant's supporters started showing up at the courthouse. Signs, chants, accusations of judicial corruption. Online, it got darker. Judge Caldwell's home address was posted on social media. His family members were identified and harassed. Threats started appearing, subtle at first, then increasingly explicit. The U.S. Marshal Service assigned a protection detail to Judge Caldwell. His wife and children were moved to an undisclosed location, all because Harrison couldn't keep his mouth shut. This is exactly what witness tampering looks like at scale, one former prosecutor observed. They're trying to intimidate the judge the same way they allegedly intimidated the witness. It's the same playbook, just bigger. The defendant's family released their own statement. Our loved one is being railroaded by a rogue judge who has decided guilt before trial. We call on all Americans who believe in justice to stand against this abuse of power. Federal security protocols at the courthouse have been elevated to their highest level, and Judge Caldwell, he hasn't said a word publicly since that day in the courtroom. Not one word, which tells you everything about who's actually in control of the situation. But here's what's bothering me. Why was that microphone still active? The courthouse audio system has been in place for 12 years. This kind of glitch, quote unquote, has never happened before, ever. Who was the unidentified voice on the recording? It wasn't identified in any of the court filings. The investigation isn't saying. And why did the defense team's behavior change so dramatically 3 weeks before trial? The exact time Maria Delgado's testimony suddenly shifted. Sources close to the investigation are telling me the forensic analysis of those seized devices is revealing significant irregularities, whatever that means. The FBI's Public Corruption Unit has reportedly taken lead on the investigation. That's not normal for a witness tampering case. That level of involvement suggests they're looking at something bigger, something connected to people with more power than a defense attorney. The defendant in this case has ties to political figures, ties to major donors, ties to people who do not want their names in federal court documents. Judge Caldwell knew this case was explosive when he took it. What if the defense team's behavior wasn't just about winning a case? What if it was about protecting someone else entirely? Something is building, and when it breaks, it won't just be attorneys who fall. Subscribe now, because the moment something breaks in this investigation, I'll be covering it. Turn on notifications. This story is moving fast, and the next development could drop at any moment. You'll want to be here when it does. Here's where things stand right now. The trial remains suspended indefinitely. The defendant is in custody. Bail revoked pending investigation into whether the defense team's conduct compromised the entire case. Harrison and 2 other defense attorneys have been suspended from practice pending bar investigation. Their law firm has gone dark. Website offline, phones unanswered, office reportedly emptied. The seized devices are in FBI custody. Forensic analysis is ongoing. No timeline for completion has been released. But here's what's not in any official report. Multiple sources say the recording captured more than what's been publicly disclosed. The full audio is allegedly over 6 minutes long, but only portions have been referenced in court filings. What's on the rest of that recording? Judge Caldwell has filed a motion to have the entire audio entered under seal, suggesting the contents are sensitive to ongoing national investigations, not local, not state, national. That's a word choice that doesn't happen by accident. The next hearing is scheduled for 3 weeks from now. Judge Caldwell will decide whether to declare a mistrial or attempt to continue with new defense counsel, but everyone knows whatever's on those devices will determine what happens next. The clock is ticking, but here's what's keeping me up at night. Judge Caldwell is under 24-hour protection right now. His family is in hiding. His courtroom has become a fortress. On the surface, it looks like a judge who caught corruption and is paying the price for doing the right thing. But I've been doing this long enough to know stories like this never end clean. There are whispers that the technical glitch wasn't a glitch at all, that someone wanted that recording to be captured. There are rumors that Judge Caldwell was warned about this defense team before the trial even started, and that the warning came from inside the courthouse. There's one detail no one has been able to explain: the unidentified voice on the recording. Voice analysis reportedly links it to someone in federal law enforcement, not a witness, not an outside conspirator, but an insider. So what is this really about? A courageous judge uncovering corruption, or something far more complex? A trap within a trap, involving players we haven't even identified yet? I don't have the answers yet, but one thing is clear: whatever comes next will be bigger than anyone expects. The real question is, will you be watching when it happens? Subscribe and turn on notifications, because something big is about to unfold.